Good afternoon. Thank you, Chairman Smith, Chairwoman Young, members of the committee. My name is Mike Admirand. I'm a senior attorney in the Capital Litigation Unit at the Southern Center for Human Rights here in Atlanta. My colleague, Patrick Mulvaney, who is the managing attorney of the unit, is with me, and I see Maisie Lynn Gerton from GACTL has also joined. I'm going to try to be brief. I have a couple of big picture responses to what you've heard this afternoon, and then some more technical ones on the bill itself and the proposed procedure that I'd like to address. The first is you heard Ms. Ross say that Georgia was the first state in the country to exempt intellectually disabled people from execution, and that is true, and we deserve a lot of credit for it. But we should also take something from the fact that every single state in the country looked to what Georgia did and chose a completely different option. And they chose a different option in two ways. First, no state decided to set the standard at beyond a reasonable doubt. And second, no state asked a jury to decide at the same time that they were deciding guilt that a person was also intellectually disabled. So we have an outlier process. And if you look to what the U.S. Supreme Court has done when other states have outlier processes, I think we can see what's coming down the pike here in Georgia unless there's a change. Florida had an outlier process where they used a strict cutoff. You had to have an IQ of 75 to even make a claim. And the U.S. Supreme Court upheld that statute for years and years and years until they finally stepped in and decided after years of challenges to invalidate it. Louisiana had its, and I used to practice in Louisiana, Louisiana had an outlier process where there was a pretty high threshold to even present evidence of someone's intellectual disability. It was challenged for years and years and years, upheld, until finally in 2015 the U.S. Supreme Court stepped in and decided to do something about it. More recently in 2017, Texas's procedure, which used the novel of Mice and Men to inform its process for intellectual disability claims. That had been challenged since the day Atkins was decided in 2002. 15 years go by of the U.S. Supreme Court upholding it until they decide, actually, no, that's not acceptable. Georgia, the same thing has happened here. Yes, the statute's been challenged time and time again, and it will continue to be challenged time and time again unless and until the legislature changes it. And even members of the Georgia Supreme Court, other federal courts, have urged this body to do something to finally step in so that the U.S. Supreme Court doesn't have to. The second point I'd like to make is, Ms. Ross mentioned that just one person over the last 35 years of Georgia statute, 38 years rather, has been found intellectually disabled by a jury. And she suggests that that's not evidence that it's unconstitutional, just that it's rare. She also said, what that number doesn't capture is all the cases where we agree. The parties come together and agree that someone's intellectually disabled. But she also said that frequently the state and defense don't agree. And the whole point of Atkins is that the Constitution protects more than just the people that the state thinks it should protect. There are going to be cases at the margins where we have compelling evidence of intellectual disability, but it's impossible to meet a standard beyond a reasonable doubt. Medical experts have said that they don't meet that standard beyond a reasonable doubt because you can't do that scientifically. There's no other place in Georgia law that requires someone to prove their intellectual disability beyond a reasonable doubt. It is just this specific process. The third point is regarding the current cases, the Attorney General's involvement, and of course you should consult the Attorney General. But what this bill does, this bill says nothing about people who are currently on death row. When I was here a couple of years ago, and I checked my memory, but I believe the number that we verified was 4 people on Georgia's death row out of 40 had raised claims of intellectual disability. This bill says nothing about those people. This is purely about people who are currently facing trial and facing capital prosecution, not about the people who are currently on death row, and it does nothing to change the definition of intellectual disability. Regarding some of the specific concerns with the legislation that came up. The first is the pretrial hearing and taking the decision out of the hands of the jury in their formulation. A couple of points. One is that under this version, that hearing is optional. A defense can file a motion for a pretrial determination before a judge, and the judge can deny it. The only time a pretrial hearing is ever required under this proposed legislation is if the two sides agree that a pretrial determination should happen. So, if the judge has a hearing and denies the intellectual disability claim, it'll still be in the hands of the jury just as well. Or if the judge just denies the motion altogether, it'll still go to the jury. The second point regarding the state's right to appeal, I will say that on lines 208 and 209 of the proposed legislation, there's inserted in there specific language authorizing the right to appeal pretrial a determination of intellectual disability. And the purpose of that was intended to give both sides, including the state, the right to appeal. Before the hearing started, they said that we would have to put that grant in a different statutory section. There's no objection to that. That's an easy change to make. We were trying to give both sides the right to appeal. I also want to emphasize that there are, from the defense perspective, no new appeals authorized in this legislation. Every appeal, including the one I was just talking about, already occurs. The only new appeal that would happen if this legislation were adopted is that the state would get a new right to appeal an adverse intellectual disability determination. And then the final change regarded the verdict, which on lines 64 and 65, some concerns that takes out a guilty but intellectual disability verdict. That could just be sloppy drafting. I don't know any judge who would instruct that a guilty finding is not required, but be that as it may, that's an easy concern to hash out and not one that should hold up the broader picture of the bill. I'll be happy to answer questions. I don't know if my colleagues here have other remarks.